I'm sure I didn't say that, but I do have a very supportive husband.
Well, because he's watching, you'll deny it. Anyway, in terms of your spreadsheet, I think
Yes.
mine misses a week. You say 49 weeks, and I take your word for it.
Yes, the spreadsheet, I must just bring it to your attention, perhaps. The one that I've just received is different
Yeah,
from the one that I've sent you.
yeah.
I know you don't want to believe me that in the third term of 2023, you gave me 3 urgent weeks, but you did give me 3 urgent weeks in that one term. And I do want to point that out.
Because as I say, I take your word for
Yes.
it. Which year and which term?
The third term of 2023.
I see. So that ups your agent court weeks to
4.
to 4.
Yes, so I did 3 in that term, and then I did 1 in the third term.
Okay. So you
which
did
just
4
passed,
agent weeks.
yes.
Thank you very much for that correction. And that's one of the heavy duty areas.
Yes.
You agree with that? And the norm is you don't get, because there's 2 judges there.
Yes.
We're only starting this term that we're putting 3
yes.
judges because it's quite heavy.
Yes.
But you acted when there were 2 judges, and the norm is you get something like 30 or so
Yes.
opposed agent applications to deal with. Is it?
So I didn't get quite 30. The first urgent court was during the recess.
Yes.
That was with Judge Sinyati. And I was told that was quite a calm, urgent week. I got big cases, but not many cases.
Does recess, yeah.
Yes, and then I did. Now I must remember. Then I did another urgent in Pretoria with Judge Adams. So he did the urgent in Pretoria.
During term.
And there I got about 22.
Yeah.
And then I did another urgent in Johannesburg with Judge Opperman. And I think she was taking care of me in not giving me a too heavy workload, but she gave me very interesting cases, and I think that was about 15 cases, yes.
But anyway, I think the story is, the bottom line is you were able to handle all those cases.
I was, yes.
And then my spreadsheet suggests you did 2 special motion weeks.
Yes, I did.
And those judgments, how long did they take you to produce?
So the first special motion was the first big motion case that I heard. I think that was one of the judgments that was quite lengthy because it was my first judgment that I really spent time on. That took me less than 3 months. It initially took me 2 months, and then I lost the file, and then I had to type it from the...
But it took you not more than 3 months. And then you've done 4 opposed motion weeks.
Yes.
Yeah.
5.
Is it 5? Okay,
5,
sorry,
yes.
I'm shortchanging you.
You are shortchanging me, JP.
And the full court appeals, my spreadsheet mentions 3. That should be correct.
The civil full court, mine is 2.
The civil appeals is 2. I'm talking about the full court appeals where there's 3 judges.
Yes, 2.
3.
Yes, where there are 3 judges, I did 2. I did 1 in June this year and 1 in July.
Did you scribe any of those judgments?
I scribed in the June one, I scribed one with Judge Wilson and Judge Crutchfield.
Yeah.
When I sent the draft, I did not receive substantive comments. It was more about style and grammar and so on.
Yeah.
That was delivered, I think, within 2 months. The July one, I sat with Judge Leepenen and Judge Bally, and again there I only received typographical type of
That's
comments.
fine. So coming to your judgments,
Yes.
you mentioned 101 that you've set in, but those that you've scribed,
Yes.
your own judgments,
91.
91 over a 49-week
Yes.
acting stint. And I see you're one of those candidates, you don't list judgments. You do now and then list leave to appeal judgments.
Yes, so
No, you don't have to explain anything. I'm just pointing it out to you. But looking at this list, do you confirm that none of these judgments took you longer than 3 months.
I do confirm, yes.
Right. And then the CJ touched on you doing criminal work. She asked you what type of work you did. I think you missed it because she wanted to know whether you did trials.
Oh, yes.
You did trials.
I did trials. I did, I think, 4 trials.
And you finalized all of them.
I finalized all of them before the term ended.
Let me just say this. It's quite a feat to sit in criminal trial role in Gauteng and finish the term without apartheid. Because that's why we have a backlog there.
Yes.
There are all sorts of things at play in that role.
I think I was lucky in that I, in most instances, only had 1 accused. I think the problem often comes in if you have more accused with more
Yes.
legal representatives. Yes.
So the reason you were put in criminal trial role, which a lot of people don't want to or are scared of, was to give me confidence that you can stay in acting judge pool for the future. Remember,
Yes.
and for you to be exposed to that work area.
Yes.
Thank you.
Thank
And in addition to the trials, you also sat in criminal appeals.
Yes, I
Okay.
think, yes, I can show you where on the page.
No, you don't have
Okay,
to.
all right.
We don't have to. I mean, if commissioners want to confirm that with you, they will ask you.
Thank you.
So I was saying to the other candidate that I have my own scoring matrix. Out of 5, how much would you score yourself regarding reserve judgment, delivering reserve judgment? And let me tell you, if you didn't take longer than 3 months, I give you the total. If you delivered after 3 months, but not beyond 6 months, I give you 4.
Yes,
And then if the scoring reduces, the longer it takes for you to hand down judgments.
so if that's the scoring matrix, I would give myself a 5.
I see.
Yes,
And then in terms of exposure to complex work,
yes,
it's also out of, that one is out of 7.
out of 7.
How much would you score yourself? That is urgent court,
Yes,
motions, opposed motions, special motions, those 3 in particular.
I just want to say I'm somebody that's very hard on myself, so these questions, I don't know if I will answer them truthfully to myself.
No,
Yes.
that doesn't bind anyone. I just want,
And
because
I
it tells
think-
us how
yes,
confident you
I
are.
think they were quite complex matters, not necessarily in terms of the law, but in terms of, for instance, I handed down a judgment about a month ago of a matter that it was an application, there was a counter application, and then there was an intervening party.
Yes.
And those things become complex, not necessarily because of the law, but because you have to concentrate to see what fits in where and what is the relief sought and what is
Yes.
the relief that you can grant. So I've done a few of them. I've done not a tax, I don't know if customs fall under tax, but I've done a customs, that was the one special motion that I had. I've done many insolvency type cases, which can become complex at stages. Yes, and Paja is always,
No, look, I don't want you to
yes.
try and justify
Oh,
anything.
I must give you a score,
I'm,
sorry.
I'm giving
yeah.
it 7 because it's a heavily weighted area.
Yes.
Because that's the area where judges get reserved judgments,
Yes.
and their performance in this complex area
Yes.
tells me that they deserve a higher scoring or a lower scoring, depending on how they perform. So I'm asking you, out of 7, how much would you score yourself?
6.
6.
Yes.
Okay. Thank you very much. CJ, thank you very much.
Thank you.
Thank you, JP. Premier?
Thanks so much, CJ. I don't have questions that I need to pose to the candidate. Thank you.
Thank you.
Thank you, Premier. Judge President Tlaletse?
Oh, thank you.
Thank you, Professor.
Thank you.
I have looked at your rich experience in the academic field,
Yes.
and it's quite impressive.
Thank you.
And just want to get it from you, to understand from you. Given that you have gone through acting stints in the High Court, would you say they were quite beneficial for the person in opposition to go through these ranks to gain the relevant practical experience and have the feel of adjudicating cases in the actual courts. And rather than seeing yourself as, given my experience, I'd rather go to the Constitutional Court as an example. And if you've got anything to say about that, I would ask for your comment, please.
Can I just understand the question? So as an academic, having acted in Johannesburg, whether I think I have gained the necessary experience to continue in the High Court?
No, that is it advisable for at least someone to go through the ranks of the High
okay.
Court so
Yes,
that when
I
you do the
understand.
adjudicative
Yes,
work,
okay.
you've got the actual feel of
Yes.
what happens in the
Okay,
court.
now I understand the question. Thank you. So I think I was thinking about this question a lot after the previous round of interviews in April, and we have the 17th constitutional amendment that broadened the jurisdiction of the Constitutional Court to not only be restricted to constitutional matters. So the matters that serve before the Constitutional Court at the moment are really vast. They're not just focusing on, and I have also listened to Commissioner Nkaitoge's questions earlier this week about whether all matters are not constitutional matters, so I'm going to pause that just there. But the point is, it's difficult to be an academic that knows everything that will enable them to go directly to the Constitutional Court, I think. And that is because when you are in academia, you have a very specialized field of law, and you're not exposed to all areas of law. And I think that 17th constitutional amendment of the Constitution made it difficult to find an academic that can go directly from academia into the Constitutional Court without having any court experience whatsoever. I don't think it's impossible, but I think it is very difficult.
Yes.
Because the matters that I'm faced with at the High Court are things that I don't do on an everyday basis in academia. I love it because it's new and it's challenging and I love the law. But I think it would be quite daunting to sit in the Constitutional Court coming out of academia and now having to be faced with matters that I'm not familiar with. But as I said, I don't think it's impossible. I just think it would be very, very difficult.
Yes. If you may comment, would you say it may also apply to practitioners like senior advocates and the others that at least to go through then have a feel rather than go directly, given the kind of work that you're exposed to and that they may not be exposed to in their practices?
Yes, I think it will depend on the practice of the practitioners. Some practitioners have a broad practice and they practice in everything, and it's again a little bit different than coming from academia where you try and specialize in a field. But I think it will depend on the person. Again, it's not completely impossible, but I think it's difficult. Yes.
Thank you, Prof. Thank you, Chief Justice.
Thank you, JP. Commissioner Pillay?
Thank you, Chief Justice. Good morning, Prof. Duplessis.
Good morning, Advocate Pillay.
May I begin by commending you on your judgments? They're a real pleasure to read. They're well-structured, well-reasoned. There is one judgment I do want to raise with you, though.
Yes.
And I'm not sure how to refer to it. It's the ICMGDG matter.
Yes.
The one involving the relocation of
Relocation.
3 children to Belgium.
Yes.
Now, you did something quite unique in that judgment.
Yes.
At the end of it, you included an addendum
Yes.
addressed to the 3 children.
Yes.
Now, when I read the addendum as a mother,
Yes.
I found it so beautiful.
Thank you.
Because I could see what your intention was.
Yes.
But when I reflected on it as a practitioner,
Yes.
a few concerns started developing,
Yes.
and I wanted to raise those with you. Firstly, I was debating with myself whether when you include an addendum to a judgment, what the status of the addendum is. Does it form part of your reasons? And if so, is that where litigants would look for some of the reasons for your judgment? And would that inform then an application for leave to appeal? Just want to get your sense on that.
Yes, thank you. So you will see on my CV, I'm just going to say how I got to do that. I know it's unusual in the South African law context, but on my CV, I wrote a book review on the art and craft of judgment writing by Max Barrett. He's an Irish judge. And I was asked to write a review for the Journal of the South African chapter of International Association of Women Judges. And in that book, he has a whole chapter about this issue of addendums. And that is something that he does quite often, and that happens also in the English courts. For instance, in issues of immigration, where people might not be well versed with English, those type of matters. And the reasoning for attaching the addendum is to explain to the people affected by the judgment why you came to the reasons that you came to, in a way that makes the law accessible. And I think I did it from that perspective. I feel very strongly that law must be accessible to everyone, and also to those 3 children who had to move because of my order. I thought this is a chapter in their lives, and they need to understand how the judge came to that judgment. So what I did is I first wrote the judgment in the normal legal form, and then I just wrote that addendum based on the judgment. So what's in the addendum should also be in the judgment. So I think that then addresses your question, whether those are reasons. If they are reasons, to the extent that they are reasons, it's the same reasons that were given in the judgment.
And if you find in the addendum that you go beyond what is in the judgment, what happens there?
So my understanding again, and now I go back on what was written in the, I also read academic articles on this issue before I wrote that addendum, I should add, that the addendum does not form part of the judgment. So the status of that is just explanatory. Sometimes people write letters, and obviously that does not form part of the reasons or yes, I think.
And just lastly, in those jurisdictions, was there a particular legal framework which permitted the addenda to judgments?
No, I
And
think
I just want to check whether we needed a similar kind of system here. And that would, because if I was a litigant at the
Yes.
receiving end of a judgment and an
Yes.
addendum, and if I wanted to punch holes in the judgment, I would certainly argue that the addendum is part of the judgment and use that as a basis
Yes.
to attack the judgment as well.
Yes, I understand your question. I must say I haven't thoroughly thought about that. I understand from what I've read, as I said, in that book on judgment writing and how to make law accessible to people, that it's merely an explanatory of the judgment to the people who are affected by the judgment. So there's no specific legal framework. I think it's about the personality of the judge and what they seek to achieve with their judgments.
Thank you, Prof. Thank you, CJ.
Just to follow up on Commissioner Pilay's last question, and I ask you this question mindful of the dangers of arguing by way of analogy. Is a document of the nature of this revolutionary addendum any different from a media summary that would be issued by the court to explain the contents of the judgment, as long as it does not stray beyond
Yes.
what is actually contained in the judgment?
Thank you. I think that's a good analogy, except the media summary is written for the media, while this addendum is specifically written for the people who are affected by the outcome of the judgment. But I think as long as you don't stray from what is written in the judgment, it serves as a very good analogy. Thank you.
Well, the media summary is not just for the media, it's meant for
Yes,
the
yeah.
public's consumption ultimately.
Yes, but I mean, to the extent that the
Yeah, yeah.
audience for that is different.
Yes. No, I take
Thank
your
you.
point. Commissioner Nyugaito, is there a follow-up question?
No, it's a different question, so I'll be happy to wait my turn.
Then you must wait your turn. Commissioner Moiman? Is there a follow-up question, Commissioner Trolley? Okay. Go ahead, Commissioner Moiman.
Thank you, Chief Justice. Good morning to yourself and my fellow commissioners.
Good morning.
Prof.
Good morning.
Just one question from myself, emanating from your article, Rethinking Public Expropriation.
Yes.
The question that I want to pose is, what is the role of expropriation in a typical post-apartheid transformative South Africa? And the current legislation, section 25(1) and 2, and the Expropriation Act 63 of 1976, is it adequate enough to drive that agenda? Thank you, Justice. Thank you, Prof.
Thank you. Can I just get the last sentence? Is it adequate enough to?
Whether is it adequate enough to empower the expropriating authority to expropriate constitutionally?
Yes, thank you. That is, I just have to warn you, that was the topic of my doctorate, and I can speak also the whole day about that, but I won't, so I'm going to answer you hopefully shortly. I think people, no, I'm not going to go that way. So the role of expropriation in the transformation, no, I have to go that way. I think sometimes when people speak about expropriation, there's no clarity where in the land reform process it fits in. And I'm not saying it's true for you, but that's the feeling that I get when one speaks about expropriation. So expropriation is a method to acquire the land, and once the land is acquired, then it is distributed or returned, or whatever the case might be. So in as far as it plays a role in that process, it plays the role in how the land will be acquired, and if that land is acquired, what type of compensation would be paid. And I think that then gets us to Section 25(1) and then the Expropriation Act of 1975. And I understand also there's an expropriation bill in the pipeline. I think the Expropriation Act gives the authorities the power to expropriate, and the conclusion of my doctorate was basically we do need an act that is updated because of the reasons when that expropriation bill, the Expropriation Act, that's the 75 Act, was enacted. Market value compensation was the, now the word, the be all and end all, the word will come, standard of compensation. And of course, now in terms of the Constitution, Section 25(3), the compensation standard is just an equitable compensation. So there's a disjunction there. And then also the issue of public purpose. Public purpose is in the Expropriation Act of 75, and the Constitution speaks of public purpose and public interest, where public interest includes the nation's commitment to land reform. Do I think the 75 Act necessarily stands in the way?
Unjustified enrichment. So I just needed to allay your fears.
I'm
Thank you, Prof.
not scared to talk about this. Thank you.
Thank you, CJ.
Commissioner Gotze?
Chief Justice, can I just follow up on this and I'll let go of my.
Yes, Commissioner Mangan?
Yes. Good morning, Prof.
Good morning.
Thanks for the beautiful answer in relation to Section 25(3). And I see you have also written an article on the conflation between
Yes.
value and compensation.
Yes.
Applying the principle of equity, is it possible to expropriate and compensate at a zero, at a nil?
Yes. So I think what I've always said is that Section 25(3) of the Constitution says compensation must be just and equitable, taking into account the circumstances of the case. And so it will depend on the circumstances of the case. If it is a case where if you take into account all the interests involved and you do the weighing up process that is required in terms of Section 25, it might be possible that during that weighing up process, the compensation amount might fall on R0 or no, but that will depend on specific facts. So it's difficult to say definitely yes or no, but there's a weighing up process that needs to take place, and in that weighing up process, it might be, and I think the expropriation bill in clause 12 also clarify that by saying there might be instances where null compensation may be paid. So it's all about that weighing up process.
Thank you, Prof. Thank you, Chief Justice.
Commissioner Gotsa?
Thank you, Chief Justice, and good morning,
Good morning.
Professor. With reference to news reports recently that in one of Gauteng's courts, if you have a civil claim, you will only be heard in 2028.
Yes.
It was also reported.
29, actually.
29. It was recently reported that legal professionals are at their wits' end over the longest backlog in history, and I quote there. What, in your view, is a judge's role in ensuring the expedience in the administration of justice?
Yes, thank you, Commissioner Gotsa. I think, and I'm sure you know how the allocation work in the High Court. You get your role in the beginning of the term, and if you are in the Civil Trials Court, you get allocated civil trials. So I think your first obligation is to make sure that if you are allocated cases, that you see them through if possible. There are fewer delays in the civil trial court than there is in the criminal trial court, but I think for one, when a case is allocated to me and it is possible to keep the case and to see to its end, I do that because I don't see the sense in the parties re-enrolling that matter. So that might be one. Of course, case management comes in as important as well, but often also as judges, when you have a role, say you have a special motion role, and your special motion becomes settled and your week is cleared because you don't have any hearings, what judges then do is they go to the DJP wherever they sit and to say, I'm available to hear civil cases, and then they get allocated civil matters. And that is something that I've done before, that when my role finished before the end of the week and I didn't have pressing outstanding judgments, but even if I had outstanding judgments, I would still go to the DJP and say, I am open to be allocated with matters. So I think that is the extent of what judges can do. Other than I know Advocate Ali spoke about the appointment of pro bono judges and so on, but that's, I think, a different matter than what I can do if I am a judge in that circumstance.
Thank you.
Thank you.
Commissioner Nqaitobe?
Thank you, Chief Justice. Good morning, Professor du Plessis.
Good morning, Commissioner.
Like Commissioner Pillay, I must commend you on the lucidity of your judgments.
Thank you.
It's been a pleasure to read some of them.
Thank you.
One of them is a very promising one about challenging property.
Yes.
You remember the judgment?
Yes.
In the context, I think, of
Family homes.
a family house,
Yes.
juxtaposing customary law and common law property.
Yes.
But let's take the debate forward
Yes.
outside of custom.
Yes.
The problem, of course, is the right to property itself.
Yes.
And the debate was always, well, does the Constitution, in fact, embed the right to property in the negative expression in Section 25(1)? Or is the Constitution really intended to rethink the notion itself of property? Now, three of the passages in your judgment point to the problem of private property and the constitutional setting, that property by definition is exclusionary, whereas the Constitution has a more substantive understanding of this idea of the relationship, let's put this, the relationship to property.
Yes.
I want to just get a sense, because I have no doubt of your commitment to the values of the Constitution. You live them, you write about them, you are now about to apply them as a judge. Whether or not you doubt if the Constitution embraces an unbridled form of property, and whether what we can expect from you is actually a challenge to the notion itself.
Thank you very much. I think that's a difficult question, so let me just readjust myself. I think for the first question, whether the Constitution protects the notion of private property, I'm paraphrasing you now and
Yes.
not very eloquently so. I think if you look at the history of the making of Section 25, you will be well aware that Section 28 of the Constitution mimicked the German Constitution, in that Section 28(1) stated clearly property is guaranteed.
And that's the interim constitution.
Yes, that's
Yes.
the interim constitution. And I think it's quite telling that that Section 28(1) did not make it to the final constitution after the deliberations in the Constitutional Assembly. And from what I understand, I've read last year, I've read all the notes on the deliberation of Section 25 in that Constitutional Assembly. That was done on purpose. And if you also read, there's a book by Justice Albie Sachs, Oliver Tambo's Dream, I think. In there, he spoke about that issue where he said that was deliberately left open not to solidify private property in the Constitution, because that was seen to be a political contestation in a sense. So that's the answer there. But I do understand when people criticize the Constitution by saying, well, Section 25(1) says that the state cannot interfere in, nobody may be deprived of property unless, arbitrarily deprived of property unless in terms of a law of general application. And in that sense, it might be interpreted that it does solidify private property. So I think that answers that question. But I think what is more important is if we think about property in terms of the Constitution, and that's certainly something that I have written about academically. I've recently also written in an eviction case about that. That idea that property can only mean ownership, and that ownership can only mean ownership to the exclusion of everyone else. That is what we are challenged to interrogate under the Constitution. I know Professor André van der Walt wrote this article where he said that notion that we have this hierarchy of rights with ownership at the top and all the other rights at the bottom, it was used by the apartheid government to protect white ownership of land. And what we now need to do is we need to open up that, so that in some instances, right in property that might not be ownership can challenge those notions of ownership. And we already see that in eviction law, for instance. There are some instances where the owner of the land cannot evict somebody who has the right to not be evicted if it's equitable to do so. And that brings in a challenge in the property law sphere. And I think those are the type of instances that one can explore on various fronts. And I think that's what I'm trying to do in some of these judgments. And that's certainly what I did in that family home judgment, where I said there are certain rights in a house. If you have a right in the family house, it should be that in some instances that right should be able to trump the person who is the title deed holder for various reasons. And of course, there's a very fine line that the judge must walk in that regard, because it might be more of a policy or political issue. But I think one can challenge those notions if the facts of the case before you allow for that. And I think, I'm quite excited about that, as you can see.
Yes, no,
Yes.
thank you. No,
Thank
it excited me too, because we've lived for 30 years
Yes.
in a straitjacket of the common law of property, and with judges reinforcing
Yes.
the straitjacket. With your judgment, there were other judgments we were debating earlier from Judge Cowen that are beginning to actually open up the space so that the Constitution means something.
Thank
So it's an exciting start. So, but my understanding of your answer is that you will continue to entrench that
I'm glad
vein
it's
of thinking.
visible. I'm glad that effort is visible. Thank you.
Yes. Now, the second thing,
Yes.
it's around expropriation.
Yes.
The people talk of market value
Yes.
in an expropriation. Now, I've argued that it is a total fiction
Yes.
because there is no market in an expropriation. There's a state is trying to acquire land for redistribution. Market value itself is also a fiction because it presupposes a willing seller with a willing buyer, and both of them are ignorant as to the real price. But we know that doesn't actually exist. But do you also agree, or do you have a different view about the utility, maybe futility really, of applying market value in expropriations? That was a fundamental mistake committed by the early constitutional court in thinking that market value could be a starting point when it specifically deals with land reform, and whether you think actually land reform should be thought differently than any other forms of property because it's about addressing the original sin, and whether there are constitutional ways that you've thought about that we can actually start to challenge. It's also another straitjacket that has constrained proper land reform.
Yes, again, that was exactly what my doctorate was about. I'm not going to repeat that. And I think the position I held then was I was also saddened. It was a Du Toit judgment, which was incidentally not a land reform judgment, that said we start with market value. And again, that then places market value at the center of the inquiry. But I have since developed a more nuanced approach because I do understand that when you do come to court and you want to argue about compensation, in the end, the court must give
Give a number.
Give a number.
Yes.
And
But I mean, Judge Cowen says
Yes.
that's not the case. You don't always have to give a number. And even if you do have to give a number, you can start with current use of the property
Yes.
and try to give a number to that.
yes, I think where I want to get at is you will see there was a later article on the disjunction between value and compensation.
Yes.
Because it becomes more complicated when you start to ask the question, who's got the authority to make that determination? And you will know from the Malmuth judgment where the OVG said that the Land Claims Commission in that case is bound by her determination, and the Land Claims Commissioner wanted to have some leeway to be able to negotiate. Then that issue of value and compensation comes in. So what I want to say is I've moved a little bit to a more nuanced approach where I said, okay, I understand why you have to give a certain value. It does not have to be market value. We have to have a certain value to work from. And so in my writings, I say that should be the job of the valuers and the OVG. But in doing that job, they must say these are all the factors that we could see on the ground that might influence the decision maker in coming to a compensation amount, because a compensation amount must be just and equitable. And justice and equity, and there I then totally agree with Judge Cohen, and I think you've made similar points, that it's justice and equity that informs compensation. But if you can keep these two things separate to an extent without placing value in the center, but understanding that value needs to form part of all those factors that you take into account by coming to a compensation amount, and that compensation must be just and equitable, so it's justice and equity that inform that amount, then I think we are moving.
So that's also part of the philosophy you're bringing into the system.
Yes. I hope
Well,
so.
both of those answers are excellent and music to my ears. I hope, long may they continue to percolate.
Thank
Are you
you.
going to act in the Land Claims Court if
Advocate Nova,
invited?
Advocate
Oh, sorry,
Nova,
Chief Justice. Yeah.
It is a critical difficult and gripping subject. We acknowledge that, but let's wrap it up. There are 7 other candidates still to be
Yes,
interviewed.
that was
And
just to
I
ask.
would ask our expert to please keep your answers as concise as
I'll
possible.
try. Don't ask me expropriation questions. I've got much to say.
No, it's just to ask her whether, if appointed, she would make herself available to the Land Claims Court.
You may ask that question.
All right. Well, you've heard the question, Professor.
Yes, I'm willing to make myself available to the Land Claims Court. I'm already with my academic hat on, helping with that historical cases project. So I'll be more than willing to continue with that. Thank you.
Okay. Commissioner Trollip?
Thank you, Chief Justice. Professor Duplessis, I'm largely covered by your responses to Advocate Mukai Tobi.
Thank you.
When the Chief Justice asked you about your studies, you said something about, you wanted to finish in a hurry because you didn't think they'd be relevant for much longer. Could you just expand briefly on that? And then while you're doing that, could you explain, I understand that the market value concept is outdated. It was relevant to a 1975 Act and all of your responses thereto. Can you explain the difference between market value and current use value and attaching a numerical number to current land use?
Okay. The question about outdated was the market value. Can I just answer just the market value question now and the current use?
You've already answered the market value one,
Yes.
as far as I'm concerned.
Yes, okay.
The new parlance is current use.
Yes.
Can you just explain the difference between the two?
I hope I'm going to remember the nuances, because you've got the expropriation, the Property Valuation Act, and in terms of the Property Valuation Act, there were regulations published that looks at the current use value. And that was the subject in the Moloto judgment that was also spoken about earlier this week with Judge Cohen. And I agree with Judge Cohen in what she wrote there in that judgment. But the problem in that judgment links with the regulations in that it's very technical, so I hope I remember how that current use value is explained in the regulations. But the way that the current use value is set out in the regulations, I'm just going to leave it at that, is problematic. And I think the nuances of all that came out in the Moloto judgment, and I fully agree with Judge Cohen's judgment there. So I think that would be my short answer in the interest of time.
Chief Justice, just to follow up, and your short answer about hurrying up your studies because they wouldn't be relevant for much longer.
Oh, that was. So in 2008, there was an expropriation bill, and I finished my doctorate at the end of 2008, and I was afraid that that bill will be passed before my doctorate is finished, but that bill was then shelved eventually, and then there was 2013, and then for a long time I did not do any research on expropriation because it seemed to be dormant. And then, of course, as we all know, in 2018 that changed. So it's just the nature of academia. You try and contribute with your research. Yes.
Thank you, Chief Justice.
Thank you.
Commissioner Marumagai? Professor? Commissioner Breitenbach? It's not frozen or anything like that, is it? Okay. I'll take that to mean they no longer have need to ask you questions, Professor de Villiers. Was there another hand? What did I call her? Oh my goodness. Well, maybe. Well, let me not say what I wanted to say. Commissioner Mangia?
A short one. Professor, I see you wrote an article on the meaning of a home in the context of Section 26(3) of the Constitution.
Yes.
And you also wrote a commentary on a SCA judgment of Ngomane versus City of Joburg,
Yes.
the unanimous judgment that was penned by the CJ. And you were critical of the meaning of the word home as defined in the approach that was taken by the SCA. And you would know that subsequently and recently, the SCA, in the case of students, I'm trying to
Yes.
recall, stay at South Point Property versus Mkulwana, a judgment of Judge Antahalter. The CA said that the residents where students stay for the duration of the academic year, it's not a home. And given the fact that you were free to comment as an academic, now that you are going to be a judge, how do you navigate academic freedom with the principle of precedence, stare decisis or stare decisis, whatever they call it?
Thank you. That's a wonderful question. I've asked myself that many times during my acting stints, because now already I was wearing two hats and I had to be careful. I just want to clarify that chapter that I wrote on the meaning of home was in 2015, and it's only later that the Ngomane judgment came out. So I just said that the work that I did in my academia was relevant for us to understand the Constitution, for example, and then I gave that example. So I was not referring to that judgment in my academic work. But I take the point that you say, and it is, of course, a little bit of a mind shift that I have to make when I am an academic. I can engage with judgments critically, and I can express my opinion respectfully. So I hope I've always done that respectfully, to show where there's room for development. But I accept that when I am a judge in the High Court of Johannesburg, that I'm bound by the president, by the judgments of the courts above me. So I did judicial training as well, and that question came up in a exercise that we had to do, and I didn't agree with the reasoning in a constitutional court. I agreed with the outcome, but not with the reasoning. And in that training session, I asked the constitutional court judges, what should I as a high court judge do in instances like that, where I don't fully agree with the reasoning in the constitutional court? And I understand from the answer, I'm bound by it. Some constitutional court judges said you can mention it, but you remain bound by it. So I know that there's a nuance, and I know that I will have to, in some instances, make that mind shift, but I think I do so fully aware of what is expected from me. Thank you.
Thank you, Chief Justice.
Thank you, Commissioner Mangen. Professor du Plessis, there are no more questions for you.
Thank you.
Unless there's anything you wish to raise with us, you may be excused.
Nothing to raise. Thank you very much for the opportunity. Thank you, commissioners.
I think the questions about the backlog 2029 and whatever can be answered by candidates or by myself as a head of court. But I refrain from raising it with this candidate because the short answer is, Commissioner Gotzel, is judges in the civil trial role are not more than 10 per day. And the allocation there is 50 matters in Pretoria and 20 in Joburg. Naturally,
Good morning, Advocate Lapuskarne.
Good morning, CJ.
How are you?
I'm very well, thank you. And yourself?
I'm fine, thank you. You hold 4 degrees, all which you obtained cum laude.
I must confess the last one was the upper second. That wasn't cum laude, that was in Cambridge. But the
Now I
others were
feel
cum laude.
better. Okay. Or a BCL, a BA honors, an LLB, and the LLM, for which you did not get the honors. Okay. You did articles successfully, but then chose not to join the sidebar.
That's correct.
You started practicing as an advocate in 1988 already,
That's correct.
and you've been at the bar since.
That's correct. So for the year that I went to Cambridge.
Yes. Is that the Johannesburg bar?
No, Pretoria.
Sorry, Pretoria, yes. Okay. You explain in your application form that your practice or your junior practice included matrimonial law, criminal law, labor law, personal injury law, and the spectrum of commercial law, including, and I'll just mention the ones that interest me, banking, insurance, and construction law, and intellectual property law.
That's correct.
And you've done pretty much everything, I take it. And you've also sat in arbitrations.
I appeared in arbitrations and I've sat as the arbitrator as well.
When did you take silk?
2006.
Okay. You mentioned that you also sat as a member of the Labor Appeal Court prior the Labor Relations Act.
That's right, yes.
Was that frequent?
A few times, yes. I was doing quite a lot of labor at that time.
Okay. Well, you are credited for leading the transformation initiative of bringing in Black junior counsel into your chambers, and not ending it there, but mentoring many Black junior advocates in Pretoria. Is that so?
That is correct.
And you have participated in the pupil training committee as well?
That's correct. Yes.
Okay. You also lectured at the University of Pretoria.
Yes, that was...
That was before, was that before you served articles?
Yes, it was while I was doing my LLB. I was doing a BA Honours in Latin at the same time, and I was a junior lecturer in Latin at that time, when Latin was still a compulsory subject for LLB as well.
Yep. So you've practiced for 36 years?
Yes.
And for how long did you act as a judge? Have you acted as a judge?
Yes, it's 19 weeks.
19 weeks, which is
Yes.
not a long time.
It's almost 5 months, yes.
Yeah. But what kind of work did you do during that? Was it one acting stint or a collection?
No, it was spread over a number of stints. And there is a breakdown which the JP has provided of what I've done. The only aspects which I haven't been involved in as a judge is as in respect of the tax court and also the criminal trials themselves. I've done a few stints in the appeals of criminal matters.
But no criminal trial as yet?
No trial. Yes, as junior counsel, I would have appeared in criminal matters representing defendants, but I haven't presided.
Okay. And you claim to have written about 50 judgments during those stints?
That's correct, yes.
Okay. Any of those reported?
Not that I'm aware of. I find most of them on Safely. I haven't checked whether they've been. They're in the law reports that I couldn't do.
And you don't have any reserve judgments?
None.
All right, I'm going to hand over to Judge President Milambo to take you through the paces about the rest.
Thank you, CJ.
Thank you very much, Chief Justice. Good morning, Advocate Labuskachne.
Good morning, JP.
Let's just place on record that you are also here because of discussions between yourself and myself in the last 2 years.
That is correct.
When you raised your hand then that you'd like to become permanent, and then I said to you, I will give you the nod when I think the time is right for you to come and face this body.
That is correct.
Right. My spreadsheet that I've given to the commission misses 5 weeks. You say you've done 19 weeks, and I apologize for that.
Yes. 2006, in the year in which I took Silk, I did 2 weeks, and then again in 2008. There's another 2 weeks.
Those are the two. That's two. That takes it to 18.
There's a week missing which I can't find.
Okay. Well, 2006, 2008, I was a puny judge, so I don't know what happened then. But anyway, sorry about it.
Yes.
The moral of why I'm asking this is, in my spreadsheet, you've done 3 agent court weeks.
That's correct.
That was in Pretoria.
Yes.
Was it during term or during recess?
They were during term.
So you would have
check
faced
that.
the full load of the agent allocation.
Yes, I was there at the time when there were only 2 judges.
Yeah. And then, well, the commission knows the average allocation load in the agent court. And then you've done 2 special motions.
Special motions, yes, I've done 2. That's right.
Yeah. If you think you've done more, you must tell me, because
Yes. Well, those were where I was on the roll, the duty roll for that week. I might just mention, JP, that as far as criminal appeals are concerned, the spreadsheet misses 1 term in 2021 and another one in 2023. I've did 2 stints with criminal appeals.
Thank you very much. And then in terms of opposed motions, I've got 3 weeks here.
That's correct, yes.
Yeah. Now, what you said to me when we spoke about your availability, I said, my preference in giving the nod to candidates to avail themselves of judicial appointment is that in the sunset period of your acting, I would like you to do a full term.
Yes.
You remember, and you told me that it would be difficult for you to give me a full term because of your practice.
Yes, I have a very busy practice, and the overheads are such that to be away for 3 months casts a shadow of another 3 months. It's effectively being out of private practice for 6 months. It's just too expensive.
Yeah. But I think what you said, which I think is justified, you said what compensates for not doing a full term is that your practice is predominantly, if not entirely, high court practice.
That's correct, yes.
Right. Thank you very much. And in terms of the judgments you've written, the spreadsheet I have, or the document I have, does not indicate the periods. But I think in one of the answers you gave to the CJ is that you give judgments timelessly. But have you given, or let me ask you this, have I ever confronted you about reserve judgment?
No, JP, my judgments are done by the time my acting stint is over.
I see. So all of them within 3 months?
Yes.
You've never had occasion to go beyond 3 months?
Well, a few days perhaps afterwards, if applications for leave to appeal would come in, that I would hear later, yes. But I've made a point of being prompt.
The judgments themselves?
The judgments are finalized.
Within 3 months. I know there's one leave to appeal that you did when you were somewhere in the US. Was it the US?
That was correct, yes. It's the first matter I was referring to. It's the United States Polo Association. It was a fight between trademark competitors, and the one was contending that the other's goods in the harbor are counterfeit.
Yeah.
And 3 judgments flowed from that. One on the merits, a leave to appeal, and also a Section 18(3) application. That's the one on which I was overturned in an automatic appeal.
Yeah, and That's the beauty of virtual hearings and case lines.
That's correct, yes.
Thank you. Well, yesterday, Durban Council was singing the praises of case lines. I wonder why Gauteng Council are so muted about the system, because it kept their bank balances okay during COVID, you know.
Yes, case lines is a lifesaver. I would advocate its rollout countrywide.
Yeah. So it may sound repetitive and annoying to some commissioners, but I have a scoring matrix
Yes.
in terms of how I score candidates. One of them is how the interview itself goes, but in terms of your exposure to complex work, like the special motions, the opposed motions, as well as the urgent court,
Yes.
right? As well as how you handle the work and turn around in terms of judgments.
Yes.
I've weighted that one heavily. It's got a scoring of 7.
Yes.
How much would you score yourself?
JP, it's a subjective thing. I think I did well.
You think, okay,
Um,
that's fine.
I would certainly not go less than what you've suggested. I might suggest more. But that's
Okay.
me, my objective opinion. Oh, I'm just joking.
Okay.
No.
Thank you very much.
No.
Thank you, CJ. No further questions.
Thanks, JP. Premier?
Thanks so much, Chief Justice. Good morning, Advocate.
Good morning,
Babas
Premier.
Kachni. You responded in the positive when Chief Justice said you are a champion of transformation in some of the legal work that we've done. I need to get outside that if we have ever promoted any form of transformation and where outside your workspace.
Outside of the?
Workspace.
Look, I've been involved in, as a pro bono advisor to indigent people in the city centre for more than 10 years on a regular basis. That was aimed at assisting people who can't afford legal help, who are destitute and desperate. So I was involved in that for many years. Was also involved in training. I helped the asset forfeiture unit to get their advocates ready for court appearances and to teach them courtcraft in advancing their own applications. And as far as training is concerned, it's something that I enjoy. And whenever I've worked with juniors and young advocates, not even where they are my juniors, even where they just ask advice, I'm known to have an open door policy, and there's a steady stream of youngsters who tap into my experience and my willingness to assist. And many, if not most of them, are black.
No, thank you. In the questionnaire for candidates, you proudly stipulate that the DA was outlined to secure the release of the former public protector's report. But you further indicate that you represented a formation that you don't declare in the diplomatic immunity case against Ms. Grace Mugabe. Why you are proud to declare the representation of your client in the form of the DA, but on the Grace Mugabe case, you are not declaring who's your client?
Yes. Could I just correct, when I state that I acted for the DA, it's because they instructed me. I'm not doing so as a matter of any pride. I was sitting right next to Advocate Nguka Tobe, who was representing the EFF in the same application. I think we had the same vantage point, and we were arguing the same issues. That was an interesting case where, for once, there was a unity amongst political parties who seemed to be at loggerheads on everything else. So that was an occasion when there was an alignment as far as legal approach was concerned. I happened to have been instructed by the DA. As far as the matter of Grace Mugabe was concerned, the case is cited as the DA. There were actually two applications. I was in a separate application representing the complainant, Ms. Engels, and also AfriForum, who brought a similar application. They were heard at the same time. But you will not see it in the citation. That's only for that reason that I didn't think it's necessary to.
So your client was AfriForum.
AfriForum and Ms. Engels, who was the complainant in the criminal case.
So why didn't you state it that your client is AfriForum, but when you're representing a DA, you proudly stated that you're representing the DA?
Yes, no, there's nothing sinister about that, Premier, and I've already addressed the issue whether I cited proudly or not.
Thank you.
Commissioner Hassan? Thank you very much, CJ, over here, advocate. I have two questions. I'll start with the first, relating to the UDM versus ESCOM case. And let me caveat and begin by saying, I think there's general agreement from all sides of the table that load shedding is prejudicial to the country, of course,
That's correct.
to specific sectors of public institutions, etc. I think we're all in agreement with that. That's not where my question is situated in. I think my concern, and maybe I should also say this, CJ, that I am also on the portfolio committee for electricity and energy.
Yes.
So very much involved with the NERSA issues and upcoming electricity tariffs, and perhaps maybe, let me say, very passionate about how we bring about equitable access to electricity. CJ, my question relates to the separation of powers and to, I think, very difficult legal jurisprudence that has been developing over the last few years. And while we can agree there was a need for intervention on this particular matter, I am a little bit concerned by judgments that are handed down that are frankly impossible for the state to implement. And let me explain or expatiate a little bit. We agree that police stations, schools, hospitals, etc., should not be load shed. I don't think there's anyone who disagrees with that.
Yes.
But the way the grid is designed, we can't just not load shed one particular corner of a street, right? The way the grid is designed is not that.
Yes.
And for us to literally redesign the grid would cost us trillions of rands that we do not have in the fiscus. And yes, there's an argument to be made that we're now developing transmission, etc. But I do think that and I've read the case before coming here today. So I'm trying to separate a constitutional issue with the practicality of what is possible and is not possible. And where do we get to a point where we are handing out judgments or handing down judgments for legal jurisprudence sake vis-a-vis the actual protection of the people we're trying to look after? And I'll say this by saying, if the grid collapses, and there is a blackout in this country, forget schools and police stations, you have civil unrest. And those were the kinds of contentions that we, and let me not say I was not there, I was in the legislature, but that were having to be balanced out. And I do wonder, advocate, whether those considerations played a part. And I'll say it openly, I do wonder when there is a need to overstep the separation of powers. We agree there is sometimes a need. But then the immediate pulling back. So you overstep to make a decision, yes, understandable. But then make a decision that is impossible to implement. And then again, we want to talk separation of powers. Then it's the executive that must implement a court order that is impossible to implement. So I'm just interested in the comments, CJ, and then I'll ask my second question. Thank you.
Yes. I think yes, I know which judgment you're referring to. I think one must bear in mind that if there was an overstepping of the mark by the court in granting an interdict of that nature, that there is an appellate process where corrective measures could be taken by the higher structures in assessing the reasoning of the court or quo. I'm not aware whether that matter has gone that route or not. When it comes to separation of powers, it's obviously an important consideration to ensure that there isn't judicial overreach. That does of necessity require a weighing of interests. When it comes to formulating a remedy, however, it must, I think, in principle, be capable of execution. And if it does overstep the mark, it must meet the test of being an exceptional circumstance as set out in OUTA. It cannot be a knee-jerk position to assume. It would really be exceptional. Now, I think as far as load shedding is concerned, it's been a bane of our existence for much too long. There are judgments about it, I think, in 2013 already. And the fact that it has been around for so long is really a matter of great disappointment to everybody. The solution to that, unfortunately, doesn't lie in the courts. And I think that's where courts have been trying to, I think that same judgment says the courts cannot solve load shedding. But when it comes to prioritizing who gets electricity, I think the court in that instance tried to take a position. Whether it's possible of execution, I don't know whether that was properly before the court. In the matter in which I was involved in, which was one of the related applications, we were really advancing the position of public participation in determining the allowable revenue of Eskom, and where our position was really that when NERSA itself would report 6 months before that there were billions of rands of misappropriation and within Eskom, and now has to determine allowable revenue, is it a valid question to ask whether they should be put into place precautionary measures to avoid the public purse being deprived of the benefit of public contributions? So that was a vantage point, which I think it's still to be crystallized, but our vantage point was to have the public be heard on these important issues prior to NERSA determining an allowable revenue.
Thank you, CJ. My second question, and maybe just to say that before, one of the reasons why we've put a stop or been able to put a stop to load shedding, different to load reduction, is actually, and maybe it is important to say, not because of the rulings of that particular case I cited, is fundamentally because of the ingenuity of Minister Ramokgopa and the team. And why I'm saying that is it could be conflated that the issue of load shedding now is different because of the case. But CJ, my second question relates to, and I'm looking for it here, because as you can see, I have a lot of documents to try and find it. But just to be clear, Advocate Labuschagne, did you act in any cases involving the University of Pretoria and fees must fall activists or students?
Yes, I was involved on behalf of the University of Pretoria over many years, and the fees must fall campaign was part of it. Yes, that's correct.
Thank you, Advocate. Let me also caveat the next question by saying, which we all know, I was a foremost leader of Fees Must Fall at Wits University, a different institution, but the question is important nonetheless. Advocate, what are your views on the bullying tactics, not only by universities using top legal counsel to bully arguably a very marginalized group of people, students, who were exercising a very legitimate right to protest in view or really in finding the objective of free quality decolonized education? And I say that fundamentally because when you're a student, you have nothing. You have no money. And I'm very interested, Prof. Mr. Mangena also raised this around student housing earlier. You don't have much to leverage off with. In fact, the only thing you have to leverage off with is your potential to graduate and contribute to the economy. And I will also say that we had no money to find any sort of legal counsel. And when universities came to us, and I'll tell you an important moment during Fees Must Fall, there was a legal counsel who came to me while protesting. It's got nothing to do with you, Advocate. I'm just trying to give context. Who pointed at me and a number of other students and said, "This is the end of your legal career. We will prosecute and we will move to the very end. And there are many instances of student activists and student leaders, Kanya Eshe being one of them, Bonginkosi Kanyile, and many others who have lost every opportunity given to them because of some of the cases that emanated from those initial days. So I'm just interested, Advocate, in your thoughts around the bullying tactics of universities and council who also seek to bully the most marginalized of society.
Okay, could I address that issue from two vantage points? The first would be that in formulating applications on behalf of a university that is facing paralysis as far as lecturing is concerned and a threat to the exam program being completed, the formulation of the application and the relief sought took very careful notice of the right to protest. It's an acknowledgement. With a legitimate gripe, you have a right to protest. The question is, however, how do you exercise that right? And there, unfortunately, there were instances of criminality. There were instances, if you speak of bullying, of people walking in and hijacking classes where people were about to write their exams. Now, that type of conduct, although it makes a point, also oversteps the rights of other students to be educated. They have, after all, paid for it. So the right to protest is a right that needs to be exercised within the law. And the purpose of those applications was to ensure that that right is exercised in a way that doesn't paralyze the university, but doesn't limit their right to express whatever position they want to advance. So there was a balance involved. And I certainly don't see my own involvement as a matter of bullying. I think we were quite sensitive to the rights of students, and we were trying to balance the rights of other students and of the university to discharge its obligation of training students and affording them an opportunity to write their final exams.
I realize that I may have done you a disservice and sold you short. When you responded to my question about your acting stint that you had acted for 19 weeks, you'll recall the comment I made that that's a particularly long period of time. But then you have a vast CV, which I did not canvass. There are many aspects of it that I did not canvass with you when we spoke. And that includes features such as that in your 36 years in practice, you regularly appeared in our courts, especially the Supreme Court of Appeal and the Constitutional Court. Those are your stomping grounds.
That is correct.
And you've appeared in other courts across the borders as well on commercial matters.
That is
And
correct.
your arbitration work actually straddles continents. You've worked in countries such as China, in Asia, and Europe.
That is correct.
And you are also a published author
That is
with a knack for writing children's books,
I write children's books.
and a painter,
That is correct.
and a
I
marriage
illustrate them.
officer. All right. Oh, I did not see that hand. JP Tlalezi?
Yeah, just one aspect here, Mr. Labuskachne.
Yes, Commissioner.
Yes, I do not know whether you have attended any of the seminars or training under the auspices of SAJE, but practice has over the years has shown that counsel who come onto the bench with such vast experience do not participate at these seminars. Most of the time is that I don't think there's anything that can I still be taught at this stage, and it's normally being done during recess, and they see their recess period being more valuable to themselves and not attending this training. And one advantage of attending these trainings is that you are able to share your best practices and experience with other colleagues who are participating or attending and not necessarily being taught. Now, I'm not sure whether will you be amenable, if appointed, that you will also make a contribution by participating and also subjecting yourself to be trained in the judicial sphere. Thank you.
Commissioner, I've always been a team player, and during my acting stints in the division in which I acted, there are about once a week there are lectures for judges during lunchtime to bring them up to speed, and I attended those during my acting stints and found them very valuable. I have no reason to doubt that if offered an opportunity to attend these type of training sessions, I will first of all make myself available to be trained. I'm not above that, and I would, in time, if my skill set is recognized, I would be able to assist when asked.
Thank you, CJ.
Thank you, JP. Hands are suddenly coming up now. Commissioner Muiman.
Thank you, CJ. CJ, just one question from my side on the greetings to yourself, advocate.
Sorry, what must I do?
I was just greeting.
Good day to you, Commissioner.
Thank you, Advocate Namaskar. Just one question that I wanted to pose to you in relation to SAM versus Minister of Copta and Salga.
Yes.
The limitation clause.
Yes.
And the freedom to associate.
Yes.
Because I believe this was at the center of that judgment. The Municipal Systems Act was set aside on the basis of the fact that it contravenes the right to associate, and it limits the political rights of a municipal official.
Yes.
Yes.
That matter was argued about 2 weeks ago in the Constitutional Court, and we are awaiting judgment.
Okay.
So it went further. At the time of my application, the judgment had been granted, declaring that Section 71B unconstitutional. The impact of that section is that it precludes staff members of any municipality from holding political office. And that it is that aspect of their Section 19 rights which is limited, and the argument was, can it be justified? I can go into what the counter arguments were, but the Constitutional Court will tell us in due course what the right answer is.
I'm interested in the counter arguments because there's no right that is absolute.
There's no?
There's no right that is absolute.
That is correct, yes.
Yeah, because you can imagine a municipal manager who's at the same time a regional chairperson of a particular organization, the influence that you will have over the same political office bearers that must exercise oversight over him.
There is a risk of paralysis of a municipality due to political infighting. And the purpose of that act was to depoliticize local government and to professionalize local government positions. The counter argument was that it was a sledgehammer approach to holding political office, whereas the argument in the Constitutional Court was that there's a balancing to take place. There are a few members who hold political office, and what one does by proscribing it is to remove the prospect of manipulation of the superior position they hold as against municipal managers and councillors in a manner that disrupts functioning, because that in the end affects service delivery. And we know that service delivery is a very emotive matter which can easily escalate into violence. So the argument was that for purposes, although it's a small limitation of rights, nevertheless of a right that is significant and what was one It was hardly fought for. But the countervailing argument was that you get millions who benefit through better service delivery if the municipality is not paralyzed by infighting.
Thank you, Advocate. Thank you, CJ.
Commissioner Mkaito?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
I just want to confirm that you and I have been on the same side and also on opposing sides.
That's correct. You want to talk
Yes.
about the last one?
Yes, I know. But just a general point on the discussion with the Premier.
Yes.
I mean, there are times when an advocate gets too close to the client and they lose objectivity, which is harmful to both the advocate and the client.
Yes.
But that's not the general rule. The general rule is that you are not the spokesperson of your client. You are its advocate.
That's correct.
And you are detached from the client.
That
And
is-
if you've acted for the DA before or acted for AfriForum before, that's just part of who you are as an advocate.
Well, I might indicate that I've acted for premiers in the past as well.
Thank you.
Was that all, Commissioner?
Yes, it was all.
Sorry, CJ.
Yes, Premier?
I think Advocate Mugantobi got me wrong. I'm not questioning who Advocate Labuskaghni was representing. I was just asking disclosure. That's the only area. That in another part it was disclosed, but on the other side it was not disclosed. Representativity, I understand that fully. I just felt let me clarify that.
Yes, well, perhaps then I should make a different follow-up. Was there any specific reason for mentioning the DA? I'm not sure if you didn't mention AfriForum, but so,
I thought the candidate answered the question. He said there was nothing sinister about his intentions. I'm not sure what.
no, then I'm
further
happy
that
then
you-
if that is where it ended.
Yes.
Commissioner Pillay?
As
Follow
a
up?
follow-up,
Yes,
to that,
Commissioner Ngonyan.
I was tempted to ask. Good morning.
Good morning, Commissioner.
Advocate. As a follow-up to those questions, I was just tempted to ask you: do you belong to any political party?
I don't. I don't, and I never have.
Commissioner Pillay?
Thank you, Chief Justice. Good morning, Mr. Labuskaghni.
Good morning, Commissioner.
Mr. Mullins wrote a very interesting letter. We won't deal with much of the contents. There's one issue I do want to raise with you.
Please.
And you know that I represent the profession.
Yes.
And some of the feedback we've got from members of the profession, particularly in Pretoria, is that we should probe the commitment to transformation criterion.
Yes.
I see that Mr. Mullins says that his office is down the passage from yours, and he sees that majority of your juniors are black.
That's correct.
Do you confirm that?
Yes. Yeah.
And these juniors are being used in matters of substance, etc.
Very much so. I've had the wonderful opportunity of introducing some of them to attorneys, very large firms, and they are being briefed on their own because they've turned out to be brilliant and they're doing well, and that gives me great joy.
And there would be no reason to your mind, Advocate Labuskaghni, that there should be a concern about commitment to transformation.
Oh, no. I've done that for many years without any hope of being recognized for it. I do it because I believe it's important.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. I've not seen any hands from the virtual platform. Any questions from there?
Thank you very much, CJ. Can you hear me?
Yes, we can, Commissioner Marumafai.
Yes. On the last occasion, I struggled. I think I was not audible. But anyway, good morning, Advocate Labuskaghni.
Good morning, Commissioner.
I see that you, on your questionnaire, you say that most of your work is on administrative law and by extension, constitutional law.
Lately, yes, that's correct.
Yes. I just want to ask you a question that to some seems to be very clear, that our administrative law and in particular administrative action jurisprudence has developed to such an extent that we can say we now know when PAJA is applicable and when it is not applicable. But when one reads most of the judgments that are coming up, there seems to be some inconsistency on this too. I just want to get your view with regards to the development of the jurisprudence thus far. And what I think it's a triangle between PAJA, the Constitution, and then the principle of legality. In your own view, where are we as a country from a jurisprudential point of view in relation to judicial review? Do you believe that it is clear, you know, when you are having an issue, want to review a particular administrative action, you can go one way or the other, or do we still have some challenges in terms of the clarity of the jurisprudence? Thank you, CJ.
Commissioner, if I might just deal with it from what I think is a watershed judgment, was the Gajima judgment. And in terms thereof, organs of state do not utilize PAJA for purposes of self-reviews. It is done in terms of legality. That has clarified the position as far as most organs of state are concerned. So it's a legality test. You don't have to go through all the requirements, time-wise, etc., as far as PAJA is concerned. In the field of administrative law, the development of the jurisprudence under PAJA and under Section 1C of the Constitution, the rule of law provision, has been one of the immensely interesting things. It's almost like two parallel systems, but each one has its function, and I think that Gajima judgment has indicated which one applies where.
No, thank you very much, Advocate Labus. Thank you very much, CJ.
Thank you, Commissioner. Commissioner Notice?